Imagine walking into your sheriff's office to apply for a concealed carry permit, and they tell you, sorry, you don't qualify enough. That wasn't fiction. That was real life in places like New York and California until now. The Supreme Court just issued a ruling that's making major waves across the firearm community, and if you carry or even plan to, you need to hear this. Welcome back to Firearms Law Advisor, where we cut through the noise to bring you what actually matters for responsible gun owners. Today's story is about rights, responsibility, and a 6-3 Supreme Court decision that's changing how concealed carry laws work in America. This isn't just legal news, it's a shift in how we legally carry and protect ourselves. Let's get into it. Part 1. The 6-3 ruling explained the case was New York State Rifle and Pistol Association versus Bruin, a challenge to New York's long-standing concealed carry law. For over a century, New York required applicants to show proper cause to carry a concealed firearm in public. But here's the issue. Self-defense wasn't considered good enough. You had to prove some extra level of risk, like being stalked or facing a specific threat. If your reason didn't meet the state's narrow standard, your application was denied. But in June 2022, the Supreme Court ruled 6-3 that this law violated the Second and the 14th Amendment of the U.S. Constitution. In writing for the majority, Justice Clarence Thomas made it clear, if a law limits your Second Amendment rights, it must be consistent with the Constitution's text, history, and tradition. In plain English, modern gun laws must be rooted in historical precedent, not based on what current lawmakers think is reasonable or necessary. This ruling set a new legal standard, and it sent a clear message. You don't need to prove danger to exercise a constitutional right. Part 2. What's changing across the states? This ruling did not just affect New York. It sent ripple effects across the entire country. States like New Jersey, California, Hawaii, and Maryland had similar laws that required citizens to justify why they needed to carry a firearm. These states used a may issue model where approval was subjective and often denied without a clear reason. Now, after the Supreme Court's decision, many of these states are being pushed toward a shall issue system. That means if you meet the basic legal requirements, such as passing a background check and completing training, you must be approved. There is no longer room for personal judgment from local authorities. However, some states are responding with resistance. Instead of eliminating restrictions, they are building new legal frameworks that create more obstacles. These include extended waiting periods, more expensive and time-consuming training, and strict rules on where you can legally carry. In response to the ruling, New York passed a revised law that designates a long list of sensitive locations. These include Times Square public transportation, parks, bars, libraries, and houses of worship. Critics argue the list is so broad that it makes legal concealed carry nearly impossible, even for permit holders. When this new law was challenged, the Supreme Court chose not to intervene at this time. As a result, the debate continues in lower courts, where legal challenges are actively underway. One thing is certain, the ruling may have set the stage, but the fight is far from over. Part 3, Text, History and Tradition, the new legal test. The most important part of the Supreme Court's decision is the new legal standard it created. From this point forward, courts reviewing gun laws must ask a very specific question. Does the regulation align with the Constitution's original text? And does it reflect the history and tradition of firearms regulation in early America? This means judges can no longer rely on modern ideas about public safety or current policy preferences. Instead, they must look to how guns were regulated during the 1700s and 1800s. So if a law restricts things like magazine capacity bans, certain types of firearms, or limits where people can carry it, must be backed by clear historical examples from that period. That is a very high bar to clear, and it is already having a real impact. Several federal courts have struck down modern gun laws, including magazine limits and transportation restrictions, because they could not find any equivalent laws from the founding era. This new test text, History and Tradition, is reshaping how the Second Amendment is applied across the country. Part 4. How this impacts everyday carriers. For most gun owners living in states with strong Second Amendment protections, places like Arizona, Tennessee, or Texas, this ruling will not change much. These states already offer straightforward permit systems or allow permit lists. Carry all together. But for those in more restrictive states, this decision is a game changer. You no longer have to prove why you deserve to carry a firearm if you meet the basic legal requirements. That is enough. This restores access for thousands of people who were previously denied permits under vague and subjective standards. However, not every state is giving up quietly in response to the ruling. Some are creating new roadblocks. These include more paperwork, higher permit fees, and longer wait times. Others are introducing expanded background checks, character references, or extra training requirements to slow the process down. While these changes are being challenged in court, they show that the fight over carry rights is far from settled. The Supreme Court has spoken, but states are still finding ways to push back. For everyday gun owners, this means knowing your rights, staying informed, and being prepared to act when your freedom is tested. Part 5. What comes next? This case is not the end. It is the beginning of a new chapter and Second Amendment law. Thanks to the Supreme Court ruling, courts across the country are now being forced to re-examine a wide range of gun regulations at both the state and federal levels. That includes laws like magazine capacity limits, such as the 10-round restrictions in California and New Jersey, bans on rifles based on cosmetic features, often labeled as assault weapon bans, mandatory waiting periods even when someone has already passed a background check, storage and transportation rules, including strict locking requirements or restrictions on carrying firearms in personal vehicles. We are already seeing results. In California, a federal court has struck down the state's magazine capacity law, declaring it unconstitutional under the new legal test based on text history and tradition. And that is just the beginning. Similar lawsuits are underway in states like Illinois, Maryland, Massachusetts, and Oregon. As these cases move through the legal system, appellate courts and eventually the Supreme Court will decide how far this new framework really goes. So, what comes next? That depends on whether the courts follow the precedent that has now been firmly established. But make no mistake, this was not just one ruling, it was a spark. And now, a chain reaction has begun, one that could redefine gun rights in America for a generation. Part 6. Staying informed and responsible. Let's be clear, this is not the finish line. The opposition is not going away. States that want stricter gun laws are already working on new legislation that appears to follow the Supreme Court's ruling, but still makes it harder for law-abiding citizens to carry or own a firearm. And the media, they will continue to spin every court case, every headline, and every ruling to create fear, confusion, or doubt. That is why, now more than ever, it is critical to stay informed. Being a responsible gun owner today means more than just knowing how to handle a firearm. It means knowing the laws. It means understanding your rights, and it means standing with the community that is working to protect those rights for the next generation. We need to keep supporting the organizations doing the legal heavy lifting. Groups like Gun Owners of America, the Firearms Policy Coalition, and the Second Amendment Foundation. These are the individuals who challenge unconstitutional laws in court and win. But it does not stop there. Share real information. Talk to your friends and family. Help others understand what is happening. Because when we stay informed and engaged, we do more than defend our rights. We make them stronger for everyone. Now, I want to hear from you. Do you think this decision was overdue? Has your state changed its process or added new restrictions since the ruling? Let's talk about it in the comments below. I read everyone. If this video helped clarify what's going on, hit that like button and share it with someone who needs to understand their rights. And if you want to stay updated on changes to firearm laws, real-world gear, and carry options, make sure to subscribe. Thanks for watching. Stay informed, stay safe, and I'll see you in the next one.